When the defense asks the judge to throw your case out before you ever get to trial, and now they present the judge with an expert affirmation, an expert document, indicating that a medical expert has reviewed the records and determines that you do not have a valid basis for a case. What happens if you and your attorney do not oppose that request with your own expert documents? You want to know what happens? Come join me and let's walk through the neighborhood as I show you exactly what happens. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The short answer about what happens is your case will be dismissed. You want to know why? It's because you, as the injured patient, known as the plaintiff, when you bring a lawsuit trying to sue a doctor or a hospital in New York, you have an obligation to show that you are slightly more likely right than wrong than what you are claiming is true. And the way to do that in New York is with a medical expert. Many times it's with multiple medical experts with different specialties. We don't just get 5 doctors all in the same specialty, and now we're stacking all of them to say, hey, judge, look, we have 5 experts to say the same thing. No, no, no. When we go into court, when we go to trial, we are required to produce a medical expert to explain to the jury why he was careless and why his carelessness was a cause of your injuries and why your injuries are significant or permanent. The expert also has to explain to the jury what should have been done and how your injuries would not have occurred if your doctor had done the right thing. So now, what happens when the defense, during the course of your litigation, turns around and asks the judge to throw your case out before you ever get to trial? Well, first of all, that's known as a request for summary judgment. We call it a motion for summary judgment. And you should know that a motion is nothing more than a formal written request to the court to take some sort of action. And in this case, the action would be to dismiss your case. Summary judgment simply means that the defense wants the judge to go ahead and give them a decision in their favor, which indicates, hey, listen, we didn't have to go to trial. You go ahead, read the papers, and you'll see that we're right and the plaintiff, the injured patient, is wrong. So now they come to the judge with a set of papers, with the medical records, with the pretrial testimony, the depositions that went on up until that point. And they say, Judge, look, we have a qualified medical expert who supports our position that the injured patient does not have a valid case. And based upon that information, we want you to dismiss Oginski's client's case. And so this way we don't have to go to trial. So what happens after that? Well, the first thing that happens after we read that information and we have to digest it, now I have to go ahead and oppose their request. I have to explain to the judge why we believe we do have a valid basis for a case and why there are significant material questions of fact that the judge cannot answer and the judge cannot resolve. And instead, that can only be resolved by a jury trial. Now, what does that mean? First of all, when we go ahead and now oppose the defense's request, I must, in all instances, do that with a medical expert. I have to have my own medical expert review the defense's papers. And now we have to address their allegations step by step, line by line, to explain to the judge exactly why we are right and the defense is wrong. And in addition, we have to show the judge that there are, in fact, significant material questions of fact. What happens if we're able to do that? If we are able to do that, the judge has to deny the defense's request to throw your case out. You want to know why? It's because the judge is not the fact finder. The fact finders are the jury, 6 members of the community to decide whether you are more likely right than wrong. That's it. That's the jury's purpose. The judge is not there to do that. In these civil cases involving medical malpractice cases, the judge in almost all instances is not the one to do that. So what does it mean to decide questions of fact? Okay, so here's a perfect example. We claim that the doctor violated the basic standard of care because he did not do A, B, and C. The defense says, wait a second, no, that's not the standard of care. In a patient who comes in with the following problems, we believe that the proper standard of care was to do X, Y, and Z, which is what Dr. Jones did in this case. Now, what do we have in that instance? We have 2 qualified medical experts who are giving 2 totally opposing, diametrically opposed opinions about what should or should not be done. In that instance, the judge is not going to sit there and decide, which expert do I like better? Which expert makes more sense? I'm going to decide based upon my gut about which expert makes more sense. The answer is no, that is not what happens. When the judge recognizes that there are 2 qualified experts giving opposing opinions about the same set of facts, Now he turns around and says, you know what? Because there are significant questions of fact about who is more believable, meaning the experts in this instance, I am going to now deny the defense's request at this time, and instead I'm going to allow this case to go to trial and ultimately let a jury answer that question about which experts they believe. And in that instance, the judge would then deny the defense's request, and now we'd go forward to trial. But going back to the question I raised at the beginning of the video is, what happens if we don't go ahead and put in our own medical expert documents, called an affirmation or an affidavit, to support our claim that we have a valid case? What will happen is the judge will have no choice but to go ahead and grant the defense's request to throw your case out. Why? Because we did not have a medical expert to support your claim. In that instance in New York, the judge will have no choice, which is why it is so critical that we have a qualified medical expert explain in detail exactly why he believes that there is a valid basis for a case and that there are significant material questions of fact. So why do I share this great information with you on this beautiful walk through the neighborhood? I share it with you just to give you a sense of what really happens in these medical malpractice cases here in New York. You know, I recognize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a fantastic day.